Let's see a 2025 UPSC Law Optional Mains question. Critically examine, with the help of decided cases, the power of the President to consult the Supreme Court. It was a compulsory question for 10 marks. Why? You have to understand this was mentioned earlier in our video as an expected question before the mains, because the bill assent issue in Tamil Nadu and Honorable President Murmu's advice seeking from the Supreme Court was a burning current affairs. So this is a classic example that you should cover current affairs before your law optional mains. Come, let's give an introduction for this question. The President of India has the power to consult the Supreme Court under Article 143 of the Constitution. The power is known as the advisory jurisdiction. You all know this. But when it starts, what is the idea? This enables the President to seek the court's opinion on matters of law as well as fact. Not something normal, but one of public importance, or even on disputes arising out of pre-constitutional treaties and arrangements. The most important thing we must mention is the advice given by the Supreme Court is not binding on the President, but such advice carries a great weightage in governance, so mostly it is followed. Next, let's try to write about the scope of this Article 143. 143 has two clauses. Clause 1, the President may refer the question of law or fact of public importance for the Supreme Court's advisory opinion. Under this clause, if a question is asked, the Supreme Court may answer. Now, the Supreme Court is having a choice. It can answer, it can deny as well. Best example is In re Special Reference number 1 of 1993, which is Babri Masjid case. The President sought an opinion on whether a temple existed at Ayodhya prior to 1928. Supreme Court refused to answer this, saying that it was purely a historical, political question and not fit for legal determination. Okay, this is a classic example. Now, the other clause, that is Article 143 Clause 2, the President may refer the dispute arising from pre-constitutional treaties and agreements. But if an advice is sought to court under this clause, the court does not have any choice. It shall answer the question. Wait here. If you read the question, you will understand that it demands the critical analysis. So you have to analyze the positive and negative side of the advisory jurisdiction of the Supreme Court. Starting with the positive side, it helps to avoid constitutional crisis. Example, in re Educational, that is Kerala Educational Bill of 1958 case, first presidential reference case. Okay, we should remember that. So constitutional validity of a bill was asked even before it was passed as an act. The court clarified important points to the President, so constitutional crisis was avoided. Okay, and also advisory jurisdiction of Supreme Court provides preventive clarity. In sensitive issues, it tries to clarify a lot of things. It reinforces the doctrine of checks and balances by allowing judiciary to guide the executive. Coming to the negative side, which is the limitations, Supreme Court has discretion even to refuse. Example, Ayodhya reference case, which was not answered by the Supreme Court as it was a factual thing. Okay, that is one negative thing. Now, legally speaking, the advice is not binding, so it may be a time waste for the court. As well as the President can sometimes misuse the power to seek advice of controversial decisions, which is happening now. So here we can connect the current affairs which is happening now. Let me give you the timeline of the events. From Jan 2020 to April 2023, Tamil Nadu Assembly passes 12 bills for the assent of the governor. Mr. R.N. Ravi, our governor, under Article 200, he must give an assent, or he must reserve it, or he must deny it for reconsideration. But he delays the action. No assent, no return, kept pending for 3 years. But some of the bills were sent for reconsideration. So the Assembly repasses several bills after reconsideration. Now, instead of assenting, governor reserves many bills for the President. Due to this inaction of the governor, Tamil Nadu government approaches the Supreme Court, challenging the governor's inaction, major delay. Okay. On April 8, 2025, the Supreme Court verdict says that governor cannot keep bills pending indefinitely. He cannot exercise pocket veto. See, if a governor can keep the bills passed by the people's representative and negative it with a single man power, then where is the question of democracy? If he withholds the assent, he must return with reasons. Okay, he did not do that. If the assembly repasses it after the consideration, the governor does not have any choice. He have to sign the bill. So the court said 10 repassed bills are deemed to have received the assent. They become the law automatically without the governor's assent. Again, the same story. Now, even after the verdict, the governor still refers some bill to the president. Now, the president makes a reference under Article 143, that is seeking advisory jurisdiction from the Supreme Court, whether it can, that is Supreme Court can fix deadlines for the governor and president on assent. This matter already answered in the verdict of the Supreme Court. Yet again, it is asked in advisory jurisdiction now. Whether this advisory jurisdiction can be misused should be your conclusion.